So hello and good evening to our participants who have already joined us for our seminar. We have a large number of participants here tonight, and I can see them just dialing in as we speak. My name is David Rouse. I'm an advisor with the Housing Agency on the multi-unit development and owner management company sector. Thanks to the good offices of the Society of Chartered Surveyors Ireland and the Conveyancing Committee of the Law Society, we have about 320 people dialed into tonight's session, and you're all very welcome. You're dialed in tonight and you're logging in tonight because you care about the owners management company and multi-unit development sector. I'm conscious that we have a wide number and a wide spectrum of participants and attendees on tonight's session. We have members of the SCSI, so management agents, quantity surveyors and other property professionals in the sector. We have members of the Law Society, people who will be interested in the company law, the real estate, multi-unit development act and other aspects of the owners management company sector. So you're all very welcome here. Conscious we also have directors, volunteer directors of owners management companies dialing in tonight. So again, you're all very welcome. We have people dialing in from the Apartment Owners Network and other interested parties who were good enough to publicise the event. So as I say, you're all very welcome, and what we'll do before we start formally is we will launch a particular poll that we have ready here. So we'll launch the poll, and you might please vote on the different options that we've put up there. So you should be able to see it, so feel free to vote on the various options on your screen there as you have them, and we'll let you know the results of that poll in a couple of minutes. Just to briefly introduce our panellists this evening, we have Suzanne Bainton, who is a solicitor with Liston Company in Dublin, and Suzanne is a member of the Conveyancing Committee of the Law Society and is an expert on the multi-unit development and company law side of owners management companies. We're also joined, and we're very grateful to have Aisling Keenan with us tonight, and Aisling is the author of Owners Management Company, Best Law and Best Practice, published by Claris Press and agent in Galway and in West Ireland. So very grateful to Aisling for being here with us tonight. I can see the poll numbers are coming in very, very quickly. We have about 55% of you have kindly voted, and a quick idea of what's leading the charge. It's a fairly even split actually on the poll results between social distancing in common areas, which about 34% of you think is the most important. 30% think that owners management company finances are the most important, and about 25% are of the view that understanding what qualifies as an essential service in a multi-unit development is most important, and about 14% of you think that the holding of AGMs is the most important question, the most important issue facing OMCs during the COVID-19 scenario. So we're going to deal with all those questions, we're going to deal with all those issues in our Q&A later on. And as I said, before we get on to the Q&A and before we get on to some of our panelist views, what I'm going to do is I'm just going to end that poll now, because about 60% of you have voted, which is roughly the turnout in a national election. So we'll end that polling now, and the winner, as I say, in terms of such as it is, in terms of the most important issue, is social distancing in common areas. But there's fairly even spread between the other issues, so I'll deal with those in the course of the session as well. So Suzanne, we were just suggesting that you. Suzanne, we're suggesting you might just comment on the most significant issues facing the sector at the moment in the context of COVID-19.
Yeah, no problem. In terms of the queries we've had in, they've been mainly around issuing service charge demands in the absence of having had the budget meeting and having the budget approved, and also about going ahead with normally AGMs, but also EGMs in circumstances where they're scheduled to take place, and there's obviously the government restrictions on people meeting, etc. In terms of the meetings, whether you can, the first thing to check would be the required quorum in the constitution of the company. A lot of the constitutions will require 2 people in person to attend for there to be a valid quorum. The current restrictions do allow up to a maximum of 2 people to meet, and you'd have to consider whether you're meeting for the purpose of an essential, to make a decision in relation to an essential service. And obviously, if 2 people were to be in the same place, it would have to you'd have to respect the social distancing rules. So depending on the requirements of a quorum, it may be possible to go ahead with a general meeting in circumstances where you could comply with the requirement for your quorum, and other members could join in the meeting by Skype or Zoom or some other technology like that. To vote in the meeting, the members would have to submit a proxy. And I can talk maybe in more detail later on about submitting a proxy by email and whether it has to be signed. You can't vote by Skype or Zoom. You can only vote if you're not physically at the meeting. You can only vote either in person or by proxy. But a lot of management companies won't be able to hold meetings because they won't be able to comply with the requirement for the quorum. There's no problem with directors' meetings. The Companies Act specifically sets out, I think it's section 161, which sets out that directors can meet electronically by electronic means or by conference call. So there's no problem in relation to directors' meetings. The second issue, as I said, we've got a lot of queries on, have been whether a management company can send out a demand for a service charge in circumstances where the budget hasn't been approved as required under the Multi-Unit Developments Act of 2011. What the MUD Act says is that you cannot levy a service charge until the budget has been approved. I don't think there would be any difficulty in management companies requesting payments on account from members. Levying a service charge is imposing a service charge, and you would have a problem with future debt collection proceedings if you had levied the demand without having had the budget approved. But in terms of cash flow, and even in terms of owners having the full year or the full usual period that they have to pay their service charge, a number of owners may be quite happy to know how much the service charge is going to be for the year so they can organise their finances. Another question we've been asked is about whether you have to go to last year's budget if you are asking people to pay service charges. The MUD Act provides that you revert to last year's budget if the new budget isn't approved. But if you can't have your AGM or your budget meeting, then it's not a case of the new budget being disapproved. So I don't think there's anything to stop the directors agreeing on what they would like the budget to be, requesting payment as opposed to levying payment, and then when the budget is approved or in an amended format at a future budget meeting, then sending out the service charge demands and obviously adjusting them as needs be in terms of if owners have paid or if the amount is different. The last thing just I was going to mention at this stage was generally directors' duties. Directors, they have to act in good faith, they have to act honestly and reasonably, and these are very difficult times for anybody. And, you know, I've been asked, directors have asked, can we use the sinking fund? You know, can we do this? Can we do that? And the fundamental principle is that directors act responsibly in the best interests of the members, and that they act collectively, because, as I said, there's no difficulty with directors meeting and having making decisions, and it's important that they record the basis of those decisions if there was a question in the future about what they have decided to do. So David, they're the general points I was going to mention at this stage, if you can hear me.
Okay, great. That's super. Thanks very much. That's super. Thanks very much, Suzanne. I might throw it over to Aisling for your views, please.
Yeah, can you hear me there, David?
Yeah, perfect.
Yeah, you can hear me. Thank you for that opportunity. Just to say, I suppose, from a practical perspective, for all of those who live in multi-unit developments, it's a very trying time and it's very difficult. Multi-unit development living is all about sharing spaces, and that's exactly what COVID-19 tells us that we cannot do. We must adhere to social distancing, and I suppose first and foremost that's one of the more difficult, and of course it was alluded to earlier there by yourself and in the poll. That's one of the more problematic issues for residents in multi-unit development. So for example, where you have a small apartment block and there are a number of balconies, and the balconies are small and they're very near each other, and there are families living in these apartments and the children are playing on the balconies, and even at that stage the parents have contacted us and said that they don't feel that they're far enough away from each other, if you like. So proximity to each other is a real issue that we come across. We'll say from the services that are provided to a multi-unit development by a managing agent, I would say cleaning and caretaking and services like that on a daily basis. The questions that arise there are, how essential are the different services, and how do they fall within what the government have decided is essential services or not? And a managing agent needs to be able to determine that and to get it right. So for example, it is an essential service to have the refuse taken away every week. It is an essential service to have the corridors and the common areas cleaned every week. And the argument, of course, is that perhaps it's even more essential during COVID-19 than at any other time in terms of sanitisation and that. So there's certainly plenty of issues that arise in addition to the normal course of events when we have this COVID-19. So, for example, where there's a water leak in an apartment block. So there's a burst pipe in a hot press. To trace the water leaks in general, you might need to get into a number of different apartments. And what we have found is when we're trying to get into those apartments now, with the social distancing rules, it's making it even more cumbersome. And then you're left with a situation where, well, this can be an emergency. So even far more than an essential service, it actually can be an emergency as well. So you're trying to balance all of those and all the time comply with what is in the best interest of the safety of the resident in the building.
Great, absolutely. That's fantastic. Yeah. Any other comments to add from your side, Aisling? I think you might be muted there, Aisling. You might check your speaker.
Leslie, can you?
Yeah, perfect. Yeah, got you now. Yeah, great.
Yeah, I suppose really the practical issues on a day-to-day level, you know, that there are many of them, and that is something that the managing agents have to deal with and balance, as I say, with what the restrictions are.
Great, excellent. Thank you very much for that, Aisling. What I might do now is hand over and start dealing with our Q&A. So, Katrina, I might get you to unmute your mic there briefly for a second, and we might work off the questions that we received in via email earlier on today and yesterday. So I think the first one might be in relation to director's duties. So Katrina, if you want to perhaps read it out, and we'll take it up with Suzanne then.
Yeah, so Suzanne, it's quite long, so I'll just read the whole thing and then you can. So the question is, what are the minimum requirements to fulfil the director's duty of care? We have a small block of 40 apartments and we clean the common areas, mainly vacuum, etc., weekly. Should we now undertake additional cleaning, e.g. sanitising handrails, handles, lift buttons, etc.? What is sufficient in this case? Are displaying the health and control signs issued by the HSE sufficient?
So just briefly to say that Katrina Lawler is my colleague in the housing agency. I might have omitted to introduce her at the start, and she's helping with the Q&A. So thank you very much for that, and I'll throw it over to Suzanne perhaps.
Yeah, in terms of the director's duties, they're not any more onerous because of COVID-19. There are the obligations of the owner's management company are in the lease. So there's an obligation to provide the services, subject of course to the government restrictions in terms of only being able to provide essential services, and at the risk of repeating myself, respecting social distancing. But there's no duty above and beyond that in terms of extra cleaning. Now obviously it might be prudent to do it, and it could be helpful or certainly of reassurance to members if extra disinfecting is being done. And certainly in the publication from the housing agency, there was reference, all right, to considering, you know, additional cleaning protocols during this period. But I don't think legally you'd be in any breach if you didn't do that. So there's no there's the general obligation to act in the best interest of members, but there's no fixed legal obligation to go above and beyond what, you know, the services a management company would normally provide. In terms of putting up the signs, again, the housing agency information that I see David has put up there recommends that you might do that. That's simply a recommendation. And management companies, they're a community of owners and of residents, you know, so people are generally, there's goodwill in terms of wanting people to have information as to. But there's no, as I say, there's no additional legal obligations imposed as a result of the crisis. David, will I?
Yeah, I think that's fairly comprehensive. Aisling, unless you have anything to add, we can move on to the next question. Sorry, Aisling, you're muted there.
Now,
okay, thanks very much, Suzanne, for that. Katrina, we might push over to you. Thanks, Suzanne. Katrina, we might push over to you for the next. Yeah, Aisling, you lead to the next question while Aisling is on there, right? So, Katrina, if you want to go ahead with the next question for Aisling.
Oh, Katrina can't hear you, I think, David.
Yeah, sorry, it's all catching up with me now. Sorry, the next question for Aisling then is just risk assessment. So the question is a formal risk assessment required of the complex? This also relates to the coronavirus and particularly linked to the above. For example, do we ask contractors to cover off COVID-19 controls on their risk assessments or additional controls on contractors?
Yeah, what I would say about the risk assessments when it comes to the management company and the multi-unit development is that normally where contractors come on site and they're doing work in, we'll say, an apartment block, so if it's a firm of cleaners, for example, that firm will have their own legal obligations when it comes to their own risk assessments in terms of how they carry out the work that they're doing in the apartment block. And then after that, the management company may, in most cases, it will have its own risk assessment. And to have that modified then to provide for COVID-19 is something that it would be important for the management company to look at, but also in the main, where contractors are coming on site to carry out works, they're looking after their own risk assessments in terms of that.
Okay, so Suzanne, have you anything you'd like to add to that?
No, makes sense, yeah.
So back to Suzanne again for the next question. This just relates to service charges. So you may have covered some of this already, but I'll read the whole question anyway. We're trying to prepare for the expected reduction in people paying their service charges during the COVID-19 crisis. We have a service charges collection policy in place and follow it to the letter. We will make arrangements with owners who run into financial difficulties. There will be owners who use the situation to stop paying. My question is, what evidence should we seek from those who have lost their jobs? Many people will not be affected. We will apply the usual policy in those cases and will be compassionate with owners who are in trouble.
Yeah, I think the last sentence says it all, because we all, I'm sure, remember the recession in 2008 onwards, where, you know, a lot of people did have difficulties paying their service charges, and unfortunately service charges could be the last thing people paid. Some people seem to, you know, have the view that it was a discretionary or optional payment. So and I can understand the fear that owners will, you know, they'll deprioritise paying their service charges in the current crisis. In terms of, I don't think you can ask somebody have they lost their job. That's personal information that of course they can volunteer to you. But if somebody isn't in a position to pay their service charge, the management company has all the usual legal remedies available to it. But of course, on a practical basis, all management companies, in my experience, are willing to talk reasonably to owners who are in financial difficulties and are willing to engage reasonably with them in terms of a payment plan. And I totally agree with what the last sentence, that it's very important to be impartial and to have the same policy for all owners, whatever policy that is, that it's applied fairly and across the board, because then it's much easier to justify to owners and to defend when they feel they're not being treated fairly, if everyone is treated in the same manner.
Yeah.
The next question then for Aisling, again, we've covered some of this, but maybe not all of it, just in relation to cleaning and waste services. So the question is, I have a question with regard to cleaning of the rubbish disposal areas in our complex. The cleaning of internal common areas, I imagine, would not be deemed an essential service, but if bin areas are not cleaned, there's a potential health hazard. In general, I would think that the work done by OMC would be considered essential from the point of view that we maintain services, e.g. sewage system, fire detection and alarm system, which are essential services for the residents. I would appreciate your thoughts on whether our cleaner should continue to clean the bin areas during the present crisis. They are outdoor and she would not have to enter any building.
Yeah, again, I did refer to this earlier when we talk about the practicalities of trying to continue to run these multi-unit developments during a time of COVID-19, and what we can and cannot do and what's essential and what's not essential. Again, the argument is that cleaning of all areas in a multi-unit development could easily be seen as more essential during COVID-19 than any other time. So definitely cleaners should be there and they should be doing the work. Now, there can be difficulties with that as well. So for example, if a cleaning company who's contracted to come into the common areas and clean them makes a decision themselves that they are not working during COVID-19 because they don't have the staff, or the staff could be self-isolating and they could be operating on a skeleton staff, the resources may not be there. So again, all of these things have to be balanced with the situation as it arises, because as we well know, the whole COVID-19 situation is a fluid one, and we are all working our way through it, and it changes very, very rapidly, and it changes every day. But by and large, as it comes back to the same thing: what's essential and what's not essential, and cleaning is very essential for sure. Caretaking services are another one, we'll say, that comes into it in terms of the multi-unit development. If we have a caretaker who patrols a building, we'll say a number of times per week in the normal course of events, and that caretaker has a responsibility to carry out a number of checks, you know, checking roof doors, checking the fire alarm system, checking water pumps in the underground car parks and so on. And there are a series of health and safety checks and checking for water leaks and that's carried out on a regular basis in a multi-unit development. Well, most certainly those services are essential during COVID-19, just as they are when it isn't COVID-19, because they're health and safety items, and health and safety is important at all times, and it is essential. So I would say, if you were to look on the other side then and decide, well, okay, well, what is not essential? So we would have situations where we have been planning for works in an apartment block, like a painting scheme, for example. And so that thing, we'll say, painting of buildings, more aesthetic than anything else. No, it's not essential, and you want to have as few people congregating in a communal area as possible. So that would be an example of something that would not be deemed to be essential.
Okay, great. And then just one more question for Suzanne. Again, it's kind of probably been covered, but just for the particular question. So with some OMC AGMs falling during April and May, have you any further guidance or advice on either the deferment of AGMs or the agreement of budgets, some of which should be increasing, and then the subsequent invoicing of the new service charge year to owners? Would it be incorrect for the directors of the OMC to agree a higher budget and it subsequently gets invoiced without presenting it as an AGM? Also being aware that an increase in these current times would not be popular.
Yeah, I had one client recently ask me about that they needed to, because of fire safety works, they have a big increase in their insurance premium, and they had, you know, had to factor that into the budget, and they were very concerned that they wouldn't be able to, you know, deal with that in the current year because of what's happening. I mean, in terms of, to answer the question in order, the deferment of AGMs, what the, strictly speaking, the Companies Act says is that if there's no quorum present, the meeting can be adjourned. But if it's adjourned for any more than 30 days, the same notice has to go out again. So that's effectively postponing it and recalling it. As I said earlier, each OMC, if they wanted to consider whether they could go ahead with an AGM or a budget meeting, which is required under the Multi-Unit Developments Act, not the whole AGM, but just that part of it in terms of the approval of the budget, they could consider whether they could check the Constitution, see if you can comply with the quorum requirements, and then deal with the voting by proxy. If you can't hold it and you can't approve the budget, as I said, I don't want to repeat what I said earlier, I don't think the Multi-Unit Development Act requires you to go back to last year's budget. The Act wasn't drafted to deal with a situation like this. It assumed that your meeting would take place. I don't think there's anything to stop directors approving the budget themselves and requesting payment as opposed to levying payment. We could get into a discussion about technical breaches of the MUD Act and, you know, whether the directors would be responsible for that going forward. But I don't think there's anything wrong with requesting owners to pay based on a budget approved by the directors. And I think that is acting in the best interests of the development, because you're trying to keep the show on the road as best you can. And depending on when the financial year of the company has ended, there could be cash flow problems for the management company. And I think using the sinking fund is not a runner. I think you're much better. You'd be much better advised to send out requests for payment and to collect some funds rather than even considering going near the sinking fund.
Yeah, just one, I think we might move to some of the questions that are coming in from our participants here. Suzanne, just one that maybe leads on from the point that you were just discussing. Somebody's just asked, what provisions should directors of an OMC make for arrears in their next budget, given that we are likely going into a recession? Aisling, I don't know if you want to jump in on that.
Yeah, I mean, I know from my own perspective of, I would say, just in terms of working with groups of property owners and putting together budgets, particularly during this COVID-19 time that we're in. What I would say is that all of these owners management companies, they're all very different. There are no two the same. And while there is a set of rules such as company law and the Multi-Unit Development Act that govern them all to a certain extent, when it comes to the practicality of running each and every one of these companies, that can vary somewhat. So for example, what I come across a bit is a group of property owners who are all on the same page, who all make the same decisions together. And that decision could be, for example, we'll have our AGM online and we will all agree everything, and that they're happy to move forward in that, have the invoices issued for new service charges, and everybody moves forward by agreement. That can happen in many cases with OMCs, but of course there are certain cases where everybody must be brought to the same standard, and that really is where, as Suzanne has mentioned earlier, the technicality of company law and the Multi-Unit Developments Act must come into play there. So very much, I would say, it depends on the circumstance. And then when you have a group of property owners who may not, for many reasons, be on the same page, that you simply just apply Multi-Unit Developments Act and company law as best you can, really, you know.
And I think maybe a comment there, Aisling, would be for all the directors to talk to their agent, to talk to their solicitor. Communication is key in all this, I would have thought.
Well, yeah, of course, communication is key.
So communication with the agent, communication with the solicitor.
Yeah, that's right, it would be. Mm-hmm.
Yeah, great. So Katrina, maybe I'll bounce over to you for another question. But before I do that, I see one that has just come in on online, and it asks whether the CRO have issued any concessions or any exemptions in relation to the annual return date. And they have. Last week they issued an exemption to say that returns due between now and the end of June can be left effectively to the end of June, provided they're fully completed and all the necessary returns are filed. They can wait until the 30th of June. That information is on our finance and governance fact sheet, which we've uploaded to our website, and I showed you earlier on the slide. So hopefully that's of use. So maybe just over to you, Katrina, for the next question, please.
Yeah, they're really coming in thick and fast. I was hoping I'd be able to group them, but everybody's really given different questions. I'm going to suggest that we just go in the order they're coming in.
Sure.
So the most the one on the top of my screen anyway is relating to the renovation of property. So this is what if an apartment owner is completing a renovation of their property and they have men working on site? Can we request that they stop works? I have an investor who's currently working on 5 apartments within the one development, and they have numerous guys working on site.
And I think I might jump in there just on that as quickly to say in all this, the guidelines that have been issued and the advice that have been issued in relation to social distancing. Now there are, as our panellists have said, the essential services exemptions, and those are all listed on the gov.ie website, and every circumstance will be different, and it's for employers and employees to determine between them by reference to the guidelines and keeping in mind ultimately the health and safety and the social distancing requirements. It's for them to determine the situation for themselves, and I'd throw that open to either of our panellists if they want to take that up.
I'll let you go there, Suzanne.
Yeah. No, I totally agree with you, David. It's to be honest with you, my own view is I'm not sure how you could be continuing with an apartment renovation in view of the government restrictions, but it is up to each individual person to abide by their civic responsibilities and obligations. I don't think it's for the management company to enforce, unless of course there's an impact on other owners or it's affecting social distancing in the common areas, what they're doing within their own apartments, as long as that's not affecting anybody else. I don't see that the OMC has a role or to play or an obligation to enforce the government imposed restrictions.
And just maybe there's a question that's maybe not directly related to COVID, and we've had a few of those as well, so we'll just touch on those. And one that has come in is there a way to enforce the Mud Act when there's a fair share of owners who don't want to pay their service charges even if they can? And maybe Suzanne, I might ask you to comment on the circuit court jurisdiction and so on.
Oh, there's no quick fix to debt collection, unfortunately. I mean, we could. I mean, you can talk about withdrawal of services, you know, and parking permits, and that seems to be a lot more effective in a number of circumstances rather than the legal debt collection. But the legal process isn't quick, and it isn't. You know, you'll find that some owners will respond to the initial demand letter, others will only respond when you issue proceedings, others will only engage when you get a judgment. You know, I'm sure everybody listening will be familiar with that. And there's no doubt people will use this as an excuse, you know, not to pay, because they sometimes feel there's no immediate consequence if they don't pay the service charges. And that's where withdrawal of services can be useful. Again, you always, like you said before, David, you need to check your lease, you need to check you can withdraw services, you need to check provision of services is dependent on payment of service charges. You need to consider other tenants in apartments. There are a number of things to consider, so I'm not suggesting that that's a quick fix or a solution for every OMC. But in terms of whether there's a remedy in the Mud Act to collect service charges when people say they can't pay because of COVID-19, no is the short answer. The usual legal remedies will still apply. There's actually nothing in the Mud Act about debt collection other than that every owner has to pay. There's a statutory obligation to pay, but that has to be enforced through the courts in the usual way.
I suppose there's a kind of a dual aspect to it here. There's appealing to the better angels of people's nature to pay, because they don't want to, they shouldn't be freeloading, I suppose, to a certain extent on their neighbours, and they should like to see the best services and the best facilities and the best aesthetic, if you like, in their estate, if you want to take it to that level. And then there's the strict stick approach. Avoiding the carrot but going for the stick is Section 1810 of the Mud Act. The requirements of the lease, the contract debt, all the other, I suppose, strict legal reasons. And maybe I'll bring you in, Aisling, if you want to make a comment on that at all.
Yeah, I mean, for sure, I would say the debt collection is certainly not specific to COVID-19, that's for sure. But I think the question in relation to whether people might use that or not, that's what the question is. And really, whether they use that or don't use that, it doesn't change the process to pursuing an outstanding service charge. And we know that the process for pursuing an outstanding service charge is the debt collection process through the courts, a civil action in court. There is no other mechanism of legally collecting a debt in this country. Now, that doesn't mean, and Suzanne has referred to this herself, there's no quick fix and it's not easy. And that's why, in general, when it comes to the collection of service charges, that mechanism that we use and that we have in this country, it's not sufficient. There needs to be reform in that area. And that's something that I suppose in the longer term, the government certainly need to look at.
Great, thank you for that, Aisling. Katrina, I might pop over to you for another question there.
Yeah, I'm just watching the time here, so I'm going to go with one that we've had in from 3 different people, just on a vote basis, just in relation to the sinking fund. So there was kind of a couple of questions about this. So if the OMC run into financial difficulty, can sinking fund monies be used as an emergency supply to be replaced the following year? And then another person is again asking just if experiencing cash flow difficulties would be permissible for the directors to utilise the sinking fund.
Maybe Suzanne, you might pop in on that.
Yeah, I'm sure this reply isn't going to be popular, but no is the short answer, certainly from a legal perspective to that question. The sinking fund can only be used for certain specified purposes, and they're set out in the Mud Act: refurbishment, improvement, and non-recurring expenditure, and then professional advice on those 3 items. And indeed, there's an obligation in the Mud Act to let the owners know what you intend to use the sinking fund for. Now that isn't always possible in practical terms, because emergencies can arise during the course of a year that are appropriate for sinking fund expenditure. But the short answer to that question is no, from a legal perspective.
Yeah, Suzanne, if I could just come in at that point.
What about maybe the interaction with... Sure.
David, can you hear me there?
Yeah, go ahead.
Yeah, what I just wanted to say about what Suzanne had said there is, while she's perfectly correct in what she says, the Multi-Unit Development Act is specific in terms of what the sinking fund can and cannot be used for. And Suzanne is correct. But of course, from a practical perspective, that's all well and good. If, for example, after COVID-19, you get 60% of the property owners in the following year who don't pay their service charge, and suddenly there's not enough money to pay the insurance or the electricity bill. So now we've no lights in the common area and we have no insurance on the building, but we've 40,000 euros in the sinking fund. So from a practical perspective, this has to be looked at, as well as being cognizant of what the Act says. And it's just important to kind of be mindful of that and how these owners management companies are structured and what makes them so different to another company that, a band of legislation brought in for might apply to, and what makes it different in that regard. Yeah,
and I was going to just open up that point and come back to maybe directors' duties under company law, the overarching requirement to make sure that potentially the company doesn't, well, it's not necessarily, an OMC isn't a trading entity, but it doesn't trade while insolvent or doesn't carry on activities while insolvent, and that probably directors should probably have regard overall to the best interests of the company as a whole, and equally to its creditors and to its employees. So would that maybe overarch the, or
yeah,
sort of
I think, David, sorry, I don't want to cut across you. Yeah, I think it's a case of probably the lesser of two evils. You know, if you're down to not being able to pay the insurance or have the bins collected, then your overarching obligation, I think, to members would be to pay the insurance rather than to, you know, I won't call it a technical breach of the Mud Act, but I mean, we live in extraordinary times, you know, so I totally agree with Aisling. You know, you do need to be practical and act in the best interests of members. And if you're down to that, you know, if you're at a level that you can't pay for the insurance or you can't pay for essential services, well, then you have to act in the best interests of members and consider the lesser of two evils. Totally agree with that.
And again, we're giving, I suppose, general answers to specific questions. And, you know, just to reiterate and reinforce what we mentioned earlier, that every OMC, be it the directors or the members, the directors should talk to their solicitor, they should talk to their property management agent, they should get the advice, because that's what their professional advisor is there to do. I'm conscious I dropped out of the call a couple of times, but I'll let Katrina jump back in with a question there if she has one lined up. They're coming in thick and fast, so Katrina's doing a great job in monitoring them. I'll throw it over to you, Katrina.
Yeah, we have two that are probably linked, so I'll just read both of them, just relating to insurance and negligence. So the first question is, can I ask if there are any insurance implications arising from the crisis, e.g. implications of suspending maintenance such as servicing of gas boilers? And then there's a linked one, if routine fire maintenance visits cannot be completed due to the COVID-19 crisis and there is a fire issue on site, could the OMC still be considered as negligent in this regard in the future should a claim arise?
So I'm not sure who wants to take that tough one.
Yeah, I can take that if you like.
Yeah,
yeah, so I suppose it's a bit like debt collection. It's not specific to COVID-19, and insurance matters, you know, fall within that as well. But again, you know, from a practical perspective, we have to look at all of this in the round. If there's an issue, if there's a fire alarm system in an apartment block that needs to be maintained, generally it needs to be serviced 4 times per year to be compliant. If COVID-19 came in, we'll say a month ago, there isn't a lockdown in this country to that extent that as an essential service, such as servicing the fire alarm panel, couldn't be done. So that situation shouldn't really arise in that scenario. There was another example given in the question, and it was the servicing of gas boilers. Now, we all know that gas boilers are, you know, they'd be a very serious health and safety matter, and they do need to be serviced when they need to be serviced. So in terms of negligence for not servicing them, well, the first thing I would say is that when it comes to the common areas of an apartment block, generally there isn't any boilers that service the common areas of an apartment block, so it wouldn't be a management company issue from that perspective. If it's gas boiler inside the apartment, again, we know that that's the responsibility of the property owner. And the property owner and the management company, whether it's the management company has a gas boiler in the common area or the property owner has it inside their apartment, nothing would preclude them from their responsibility of having those serviced in general, and COVID-19 wouldn't exclude them from that, because it's an essential service, and that's what it comes back to, what the government have set out as essential services or not.
Suzanne, have you anything you'd like to add?
No, it endorsed what Aisling said. Just to mention, it's not directly related, but it is important for directors to check their own directors and officers insurance to make sure it's you know, sufficient to cover them in case anyone even you know, alleged negligence or because you know, it's very difficult for a management company to call what is or is not an essential service. There are the guidelines there from the government, but it's slightly subjective as to whether it's essential or not. So just on a practical basis, it is important that OMC directors have that D&O insurance in place in case somebody challenged a decision in the future that they had made as to whether to or not provide a service.
That's great. Thanks very much, Suzanne. Another question I see in there, which I might throw over to Aisling, is we have a roof garden. Should this be locked off during COVID-19, or should we let or trust residents observe social distancing themselves?
Well, I can only answer that question as directly as it has been put, and I would be of the view that the roof garden should be locked, because during this time, when we all have a responsibility to each other, and the managing agent to the management company and the management company to the property owner, we all have to do our best, and discouraging social distancing is part of that. Closing off a roof garden, I would imagine the roof garden would be there when people have the freedom to use it, and that when Leo Varadkar says to us that we have to stay at home, staying at home is just the best thing to do.
Okay, just one another question that came in on the if management agent or contractors are not in the position to provide the services they are contracted to provide during COVID-19, should the OMC look to reduce their fees while the slimmed down service is not being provided? I don't know if anybody's another difficult one.
Yeah, I can take that as a managing agent. I can answer that. If you can hear me there, yeah?
Yeah, perfectly.
Yeah. Okay. So yeah, I mean, I would be of the view that from a managing agent's perspective, there's no slim down of services. If anything, we need to be more vigilant. We need to look after the property owners that bit more. The business has to be done. It has to be continued by virtue of the fact that those buildings exist. And for as long as they exist, the work has to be done. Property owners have to be represented, and the service charges have to be collected. And that is all part of getting through COVID-19 from an ONC perspective and multi-unit development perspective.
Great. Next question, Katrina, maybe?
Yeah, so just still going in the order that they came in, one probably maybe for Suzanne, just in relation to payment of rent. Can you comment on a situation where tenants pay rent while the contract is still in place, or what if they renege on their rent due to COVID-19?
Yeah, that's a bit of a left field one.
Yes.
Yeah. I'm not sure, Katrina, sorry, what's the question? If you're a landlord and your tenant doesn't pay the rent?
I'm assuming that's it, yeah, but it's probably more, it does strike me as more of one for a landlord rather than an OMC.
Yeah.
Yeah.
We might stick to the OMC questions. That's a bit more of a landlord tenant one. So another question that came in was if in the instance of an individual in a resident in an estate, if it emerges that someone tests positive for COVID-19 in a complex, does the individual have to contact the OMC or managing agent? And again, I think this is back down to the government guidelines. This will be a private medical matter, and it wouldn't be something I would have thought between an OMC and a member. That's very much follow the HSE guidelines. It's a medical matter, and it's certainly a matter for someone to take the best advice of what the HSE and the Department of Health issued on their websites around the social isolation and so on. So I'm just conscious now that it's about 6:20, and with a few more questions to get through. I have shared during the presentation and while Aisling and Suzanne were speaking a number of slides that we've prepared. So anyone that wants a copy of those can contact either the Society of Chartered Surveyors or email ourselves at the Housing Agency. And the email address is mud@housingagency.ie. So that's mud@housingagency.ie. And again, a lot of this information is up on our website. We have our information sheets around 10 tips for OMCs. We have our corporate and governance and finance hints and tips there for people as well. And again, you can contact us through the email I'd mentioned. And so we might just take another question there, Katrina, if you see one popping up.
Yeah, I had a really interesting one just for a bit of a really left field. I've been asked to hire a band to help with spirits, and what if people do it themselves and have people playing music, and it turns out people gather in communal gardens, etc. Is there something we can do about this? I suppose this is going on about all the videos that are circulating from Spain and Italy of people singing to each other, but I don't know about hiring a band.
Yeah, again, I think you're back to the social distancing and the guidelines that have been issued, especially the very restrictive ones that were issued rightly restrictive that were issued on Friday night in terms of no gatherings of people who are not from the one household. So again, go on to gov.ie, go on to the COVID website, check the Department of Health, check the HSE guidelines in relation to social distancing. But those are the primary signposts that people should obey. They're not strictly company law or MUD Act or anything else. We defer to the medical experts on that one, and stay in our lane on that side of things. Maybe we might just look at the last couple of Q&As. Someone has asked about communal roof gardens and whether the same view should be taken in relation to communal garden areas as well. And I suppose there's a balance to be struck here between people getting out for their exercise and the 2 kilometre limit. So we go back again to the HSE and the Department of Health guidelines that if you can get your exercise in that common space while adhering to social distancing requirements, staying within your own household, there shouldn't be a difficulty there. Roof gardens, I suppose, are spaces where you can specifically close off and isolate. Whereas if there are areas where people typically go out for a walk, I think that sort of should come within the HSE guidelines and allow people to get their exercise and get their one trip out during the day. So it's 25 past 6. I might hand over briefly to our panelists for a last quick wrap up on any other observations that occurred to them. I think we've had an awful lot of questions there. We had over 260 people dialed in over the course of the still. Over 220 people dialed in with us as we speak. So maybe a quick wrap up from yourself, Suzanne. Probably, the HSE guidelines and they're the overarching principles that people should keep in their minds.
Oh, they are, David. And I mean, neither the Companies Act or the MUD Act were took into account COVID-19 or indeed the extensive restrictions that have been placed on people at the moment. So I think the overarching advice to directors of management companies would be that they need to act, honestly and in good faith and in the best interests of their members. And I think if that principle guides them through this, they'll be doing well.
And Ashley, maybe drop over to you for a couple of quick closing remarks, please.
Yeah, thank you, David. Just to say, I suppose, in general, to acknowledge that it's a difficult time, irrespective of whether you're living in a multi-unit development or not. But with social distancing being an issue, living in communal spaces, it does make it that bit harder for everybody. But it doesn't change the fact that multi-unit development living hinges upon the cooperation of everyone. And I would say to everybody who lives in multi-unit developments to be mindful of that and to take responsibility for themselves. We all have a part to play in this. The managing agents have their part to play to represent the management company. The management company has their part to play to represent property owners and residents, and that we all have to work together, we have to cooperate, and we have to try to get through this as best we can. It isn't easy.
Great, thanks very much, Aisling. I might briefly try and share the last few slides. So you can see there that we have the housing agency has prepared a great deal of resources on our website that you can access, and more than welcome to access those. And we have our report that we issued last June that people can get copies of online. We've done a lot of writing around the sector just to raise the profile and bring the issues out for both local authorities, approved housing bodies, solicitors, accountants, engineers, architects, company secretaries. There's been a lot of writing and a lot of information put out there. Just again to highlight Aisling's book and the handbook by the ODCE on company law, which I should say is out of date for company law. It doesn't refer to Companies Act 2014, but a lot of the guidance is very useful. To acknowledge the tonight, and that's their website. So I'm going to stop sharing now because it's affecting the quality there. Equally, I think I'll wrap up at this stage and say thanks very much to our panelists. Thanks very much to our panelists, to Suzanne Bainton, solicitor with Liston Company in Dublin, to Aisling Keenan, management agent with AK Property in Galway. I'd like to thank the SCSI, in particular Michelle Smith, Adele Ryan, Patrick King, who were all instrumental in organising this session online, to the Law Society, to Catherine O'Flaherty of the Conveyancing Committee. Thank you for your assistance to my own colleagues, Katrina Lawler, Mary. There was a lot of coordination. I think people found it very, very useful. Thanks to everyone for tuning in, for logging into this. It's I suppose an initiative that we thought was important at this time. We realise the challenges that people are facing and overwhelmed in their work, and we're here to help.